much. Yeah, we are recording the session, so yeah, just be aware of it. Thank you very much for joining us this morning. Werner will join us in a few minutes' time. In the meantime, I just want to give some background perhaps on what we want to achieve today and a bit about myself and the company. I'm Aubrey Snyman, the CEO of Multiprof Property Intelligence. I'm a town planner by trade, but I am passionate about connecting the dots between all the professionals in the industry, of which the property practitioners is obviously a very important part. And I think it's just exactly a month ago, things changed, and everybody that used to be estate agents became a property practitioner. And with that, obviously, a lot of additional requirements and knowledge that is required and responsibilities. So today we want to have a look at sectional titles. I'm sure most of you at some stage operate in the sectional title area and sell sections or units. With CISOS and all the rules and regulations and SPLUMA, there are a lot of things that we need to know, that you need to inform a potential buyer about, and the seller, of course, when you deal with sectional title. So we're going to look at additions and alterations. In our experience, are not many complexes where all sections are the way they were built and approved, and each alteration and change that is made have complications, and that becomes the problem of the buyer, and therefore part of the obligation of the property practitioner is to share this knowledge with a potential buyer and explain the consequences of buying that property. And therefore, it's advisable to understand what it's about so that you can be on the lookout and ask the right questions to your seller and do your own homework so that you can give a proper description of the property and the potential problems to your seller and a potential buyer. As you are seen as the expert, you cannot leave it to the seller anymore to give you answers. You need to do your homework. Can everybody please just mute themselves? We have some background noise. Please just mute yourself for the moment. So it is the responsibility of the property practitioner to get all the information and understand it. You cannot rely on your seller anymore to give you the information, because the seller don't always have that information because it wasn't given to him when he purchased the property. And there's lots of misunderstandings about sectional title, and we hope to deal with some of that today. Werner, are you available and ready? Would you like to say a few words before we start with the formal session?
Yes, I would like to. Aubrey, good morning. Can you hear me?
I can.
Brilliant. Yes, thanks a lot, Aubrey. Yeah, firstly, I just want to say welcome to all the agents or property practitioners. I really hope that you find this information session full of knowledge, and really hope that this will help you in not falling into certain pitfalls, because this can really delay the transfer process of a transaction. I'm just going to say a few things from our side regarding the participation quota of sectional title units. But first, I'd just like to just inform the agents of Vorster Incorporated Attorneys. We are presenting this presentation with specialists in the fields of sectional title plans, town planning, and also related services. So thank you for them for hosting this. Then, as most of you probably know, we are property attorneys. We specialize in the transfer of property. And COVID's been good to us, luckily. So we are expanding our business, and I'm happy to introduce that we now have 2 conveyancing attorneys. We've got 3 attorneys at our firm and 2 candidate attorneys. So and as always, we strive to give proper and good service, quick registration times to the agents. So, and if there's any questions regarding property transfers, litigation, you're always welcome to call me. We also now are involved in evictions. So if there's tenants or if you're doing rentals, we now have somebody that specializes in that as well. So with that, thank you. What we're going to do now is, from our side, explain to you the importance of today's training session. What is important for you as an agent to know is that when you sell a sectional title unit and there's been any addition that's been made to that unit, you need physical authorization for that. Now, authorization comes in a plan of, firstly, the homeowners or the body corporate. Secondly, you need authorization also from the town council, from the municipality, wherever the property is situated. And then also there's other consents that you need, and that's from the Surveyor General. And I'm sure Aubrey will inform you more regarding that and all the consents for that. Now, it sometimes happens that when you sell a sectional title unit, a stoop area or a balcony area has been closed off. The agent then, or the seller, markets his property with increased square meterage of that property, or he's closed the carport and now it's part of the square meterage of that unit. So we call that the participation quota of that unit. Now, what is important for you to know is that when that is the case, you need authorizations and consent for that, because we as the conveyancing attorney need to update the title deed. All right, firstly, and then secondly, you need authorization and from the bank in certain aspects as well. So if you don't have those consents, you cannot update the participation quota. And then also what is important, you cannot sell that property for 110 squares. So the property was registered built on 100 squares. Now the property is 110 squares. So you need certain authorizations for that. And the most important is obviously the land surveyor that will increase the participation quota. That needs to be approved by the Surveyor General. Only after that has been done, can we update the physical title deed and register the property like that. Now, what is very important to know and to realize for you as an agent when you sell a property like this, this can take a long time for this process and authority to be dealt with and accepted by all the authorities. Another pitfall is that we're currently sitting with a situation where there is 94 units in a complex. Now, if you increase your unit size with more than 10%, you need authorization from all the mortgaged properties in that complex. So what that means is that you need the bank's authority for all the units in the complex. So that is when the increase of the property in size is more than 10%. So what is important for you to know, if the unit's 100 square meters and they've added 20 square meters, we need authority from the bank. We need the bank's consent of all the units in that complex. And the reason for that is it obviously increases the value of the property, increases the levy of the property, and also it increases or decreases the risk of the other the bank or mortgage holding authorities in that complex. So for that reason, we need authority from them. So this process takes a long time. So if the increase is less than 10% or 10% and less, we do not need these authorizations, and the land surveyor can just sign off those documents that need to be approved. We can then just update it at the deeds office. So with most things in conveyancing, our process is also always the least cumbersome. For us to update that deed takes about 2-3 weeks. It's all the work that needs to be done before that deed is updated, and we have all the necessary consents from all the relevant parties. So with that being said, if you are selling a unit, there's been additions done on the unit, make sure, inform the owner or ask the owner, has he got authority to do this? Is it more than 10%? If he's got no clue what you're talking about, you know that the transfer of this property is going to take a long time. And then you also need to inform your buyer, because you are now, in terms of the Property Practitioners Act, you are liable to know about these things and also to inform your buyers in your property condition report. So make sure that you are aware of these things. If there's any questions, you're welcome to maybe raise a hand or just ask something, maybe unmute yourself and just ask a question. But that isn't short from our side. Make sure you're aware of what's going on in the complexes. And yeah, I'm sure Aubrey will be also able to answer most of your questions. So with that, thank you for the time. I hope the session helps you a lot, and we would really welcome your business. We will really appreciate if you can send us your transfers in future. We will give you good service, feedback, and proper communication and problem resolution on your files. Thanks a lot, Aubrey, and enjoy the training.
Thank you, Werner. Am I unmuted? Can you hear me? Can you hear me? Okay. You make it sound so easy. It is more complicated than that. Sorry to say, but yeah. Okay, I'm just going to share our presentation, and let's see there. Okay, yes. Can everybody see the shared screen? Just a bit about myself, and again, what we do, just for your peace of mind that we have some experience in what we're going to talk about. As I said, I'm a town planner. Multiprof, the company, do a lot of building plans. We do sectional title plans. We do valuations. We do property inspections. And by doing that, we have dealt with most of these issues that we're going to discuss. And therefore, we can give you some first-hand practical experience on what we're talking about. So we're going to do talk about the do's and don'ts of alterations in sectional title. Let me just see, how do I move this? There we go. Okay, the question is, why is alterations and improvement so complicated? As we'll go along, you realize that it is not straightforward. And the answer is fairly easy to see. We talk about communal living. A scheme is one property with lots of owners. Typically, the density is medium to high density, so you have a lot of people living in close proximity to each other, and most importantly, you have shared ownership of the common property. Then there's laws, rules, regulations, from the town planning scheme to national building regulations to the sectional title rules and regulations that needs to be adhered to. And the purpose of all of those rules is basically the safety of the occupants and the quality of life. Where you live in close proximity, what you do affects your neighbor and co-owners. It's not like where we have full title, where what you do will have little effect on your co-owners because you don't have co-owners. And therefore, it's important that all of these rules and regulations exist and that they are adhered to. In real life, unfortunately, over the last 30 odd years, not many of these rules and regulations have been adhered to. And today we sit with huge problems with illegal alterations and additions in complexes. And we have up to 75% of units in a complex that have a problem as far as that is concerned. Now, the permission to make additions and alterations, typically owners would think that this lie with the body corporate. And because of that, often an owner will write to the trustees and say, I want to enclose my balcony or my patio. And the trustees will say, okay, hereby we give you permission to enclose your patio. And they go ahead and they live happily ever after, and they think they have permission. What they don't understand is that permission given by trustees should always read, the trustees have in principle no objection to additions and or alterations on condition that the provisions of the town planning scheme, National Building Regulations, and Sectional Title Act, Sectional Title Management Act, and prescribed rules are adhered to. The approval given by the trustees have no value in itself. So you can't say the trustees gave me permission and therefore I can do what they gave me permission for. You need to comply with all other rules and regulations as well. Somehow you cannot always blame an owner because he's not in the industry and he assumes that the approval is all he needs. And then when he wants to sell and the bank wants updated plans and sectional title plans, then only they realize. Fortunately, now they have property practitioners that understand these things and they can forewarn a seller that there might be a problem. Now, the first thing we want to look at in a sectional title scheme is common property. Now, typically, there's different areas in a scheme. The inside of the section, that is the section itself, and that is what you really sell. That plus an undivided share in the common property. So all buildings that are not part of a section and all land and space that is not part of the section is common property. Typically in a scheme, all the gardens, all the parking areas, the roads is common property. So when agents used to sell a sectional title unit, they would assume that the wall around the garden indicates the garden as ownerships of the section. That is mostly incorrect, and therefore lots of people believe that they own a garden or a carport or a lapa. That is in fact not the case. There's a type of common property that we call exclusive use area. It is still common property, but it's areas that have been designated in the rules or by the land surveyor as an area that is for the exclusive use of a specific unit. And that can often be, or sometimes be, the garden area, the area where the washing line is, a carport, a parking space. But it must be provable. You need to have evidence that this is an exclusive use area. It can be in the conduct rules as well. So whenever you list a property, you need to make sure that you understand the difference and that you at least have a copy of the sectional title plans and that you have a copy of the rules. If you don't find any exclusive use areas in these documents, then it is common property. And even if you indicate the garden to the buyer that this is your garden, it will be a misrepresentation, and eventually it can cost you the transaction because it is then just normal common property. Now, let's go back a bit to issues that affect the possibility to make additions and alterations. And you need to go back to the zoning certificate of the property. Now, in the zoning certificate, you will typically see that it is zoned residential 2, and important for us is coverage. Each property, and that's now for the whole property, let's say there's 60 units, each unit is not seen as a separate entity. The property have a coverage, meaning that you can only have a certain amount of roofed area on the stand. So if there are more roofs, you cannot get them approved. The problem is when lots of carports, for instance, have been added to the scheme, and the developer have already developed most of the available coverage, it would eventually not be possible to approve building plans for more carports. And if you sold a carport as part of a section to an owner, it might be that that carport needs to be demolished, and he will obviously have a claim towards the property practitioner that misinformed him or sold him something that was not legal and that he no longer have the use for. Then there's also a site development plan that indicate all the parking, the visitors parking, garden area, and very important, minimum parking requirements. And we're going to talk about that when we look at enclosing garages for living spaces. Okay, coverage, as we said, is the percentage covered. If you look from the top, you can see here the whole red area, that is called coverage, excluding roof overhangs. The next one, we want to look at the additions and alterations, what you need to do to get additions and alterations approved. First, in most of these complexes, you have what we call a site development plan, and that is a plan indicating the position of the units, the entrances, the roadways, and what the buildings look like. So whenever you want to add any structure, you first need to make the change on the site development plan. Then you need building plans, of course, that indicates the details and the sewerage and things like that. And then if you're going to add to the PQ, as Werner said, the sectional title plans need to be updated. And then often there is restrictive title conditions in the title deed that needs to be removed. And in Swane, if you want to add to the PQ, you need to have what we call a 28.9 application. People refer to it as a SPLUMA certificate. That's not really true, but that is what we refer to. So we'll talk about that. Now, I think you're more interested in the practicalities of all these legal jargon, and therefore we decided we will have a look at each type of addition and alteration and just explain a bit of the process that needs to be followed. Werner said this takes a long time. If you have an addition where the PQ needs to be increased and no building plans exist and the site development plan needs to be updated, you can give yourself easily a year to fix it. And therefore, it is so important that when you list the property, you make sure that everything is up to date. And if it's not, that you inform the seller that it will be problematic, if not impossible, to sell this section because of the changes and alterations that was made. More often now, the banks insist on updated building plans and sectional title plans, but more important, your buyer is becoming more and more informed, and often they will insist. So even if the bank don't insist, you run the risk that you do all the effort, find a willing buyer, willing seller, and then when the OTP is drawn up, the buyer should always ask for approved building plans and up-to-date sectional title plans. And it is the responsibility of the property practitioner to warn the buyer of the possible consequences if he buy a property that is not legal. Because the moment he transfer, all the problems become the new owner's problem, and it can cost him huge amounts of money to legalize it, and sometimes he will lose some of the structures that he bought, and that may be why he bought the property. Okay, let's look at the typical requests that trustees will get, and the first is the typical carport. Most carports are added later on. It did not form part of the original structures. And as we have discussed, anything outside of the section, including the outside walls, is common property. So a carport erected, let's say, in front of the garage or attached to the house or loose standing in the parking area is physically common property. So firstly, even if the owner of the section paid for it, it is not his because it's built on common property. So we must distinguish between building plans and ownership. So in the case of any structure erected on common property, and that include inside the garden area that we would call, is common property and is for the use of anybody in the complex. Then, as we said, there's a site development plan. We need to first update the site development plan, because in the site development plan, the council checked, for instance, that the flow of traffic in the complex is positive. Now, we might think that you can put up a carport and you can still squeeze a car through the opening, but what about a fire engine? The council would look at things like the fire situation, should there be a fire in the complex, and if you erect a carport in a place and you prevent the fire brigade from getting to a unit, it may be that eventually the insurance will not pay any damages. So it's not only the carport, it has consequences. Then, of course, you need a building plan. All structures, permanent or temporary, need building plans, and that needs to be submitted to council. And then, of course, you need the inspection from the building inspector to check that the structure was erected as it was indicated on the building plan. Building plan indicate what you intend to build, but that's not necessarily what gets built. You can submit a building plan for a carport with proper steel and the proper foundation for the poles, but then when you build it, you build something else that is dangerous, that can hurt somebody, that can fall over in strong winds, and that will also affect the insurance of the property. Okay, then the second one is where you would add an additional bedroom, for instance, or a living room, or what we often see is a scullery, enclosing of a certain area close to the kitchen, and that becomes the place where the washing machine goes, and even the kitchen is extended into the area at the back of the kitchen. Now, again, as we said, anything built on the outside of your existing unit is built on common property. So that scullery technically does not belong to the owner. It belongs to everybody. But because it is used by the owner and it's an enclosed area that forms another room, that is where it's important that the PQ is increased. Now, why is the PQ important? The PQ is the participation quota, and that tells you what is your share of the buildings as a percentage of all the buildings in the scheme. And that is used to calculate your levy. So the bigger your unit, the bigger your PQ, the more levy you will pay. On the other side, if certain units have extended, but the PQ have not been increased, technically all other owners are paying some of that owner's PQ. And therefore, it is the responsibility of the body corporate to ensure that at any stage, there is enough that it's up to date. All the PQs of all the units must be up to date. Now, again, the process will be the same. A site development plan must first be updated. Then a building plan needs to be updated. Only then the construction is supposed to take place. And afterwards, you need to get a certificate of occupancy from the building inspector. And only then a land surveyor can come out. He survey the size of the addition, and he will submit updated sectional title plans to the surveyor general, and then it can go to the conveyancer, and that's where they will come in, and they will then update the title, and then the managing agent and the body corporate can adjust the levies. Now, that process, as we said, can take you anything up to a year if you from the day you start. And the problem is, it's not always even a given that those additions can be legalized. We often find that at the back of the unit, there's a gully, and the additions are done with a gully then inside the unit. And that's obviously not legal, and it can be problematic or expensive to update those. Then a very problematic issue in complexes as well is Wendy houses and lapas. Again, those Wendy's or lapas are mostly or always basically built on common property. So firstly, even if you buy a Wendy and you put it next to your unit on the grass, technically it is not yours. It belongs to everybody. And the problem is that the responsibility for it also becomes the body corporate's problem. So if a fire would start there and there was no plans approved and there was no rational fire design done for it. It might cause lots of problems with insurance if any section burned down, because the insurance will not cover you for the risk that you created by putting a wooden structure that is not treated in the complex. So the same process again. You need to change the site development plan. You need building plans. You need the inspection. And because it is a Lapa or a Wendy that have high fire risks, you also need to get a fire consultant to do a rational fire design. Often these structures are built on servitudes for municipal services, inside building lines, and it can either not be approved or it becomes very expensive and time consuming to have it approved. In cases like this, it's not necessary to increase the PQ, but at least one will have to register exclusive use areas so that the ownership of these structures can at least be rectified in some way. Another typical one is enclosing patios or balconies, and as we said, the courtyards. The owner must first establish if this patio is part of his section already, or if the balcony is part of the section, or is it common property, or is it exclusive use area. If it's common property and it's enclosed, then obviously the participation quota needs to be increased. The whole process, as we discuss every time, a site development plan must often be done mostly, then building plans, the construction, the certificate of occupancy, then the land surveyor can come in, the conveyancer, and then the levies can be adjusted. So it is not just for enclosing a balcony. Another important thing is that part of the requirements in a complex is that you need to have consistency in the appearance of units. So you can't decide, I want to enclose mine with wood and paint them pink, while everybody else have aluminium or steel. It needs to be consistent with what the rest of the units look like. And if it was done without the necessary approval, it is possible that it needs to be removed. And if you have already sold it to a buyer and he buy the property because he wants the patio, again, it can be problematic for you, because it is the responsibility of the property practitioner now to ensure that the buyer doesn't suffer any financial losses. And in a case like this, there will definitely be financial losses if you have not updated the client on the legal situation of it. Now, internal changes and converting garages, there's a myth that inside your unit you can do what you want. That is not true, purely for the reason that what you do on the inside can have an effect on the outside. Typically, removing a wall in the inside can weaken the support for the trusses on the roof. And if you remove the wrong wall, the roof will collapse or it will be damaged. And of course, the roof is the responsibility of the body corporate. And therefore, it is a fallacy that inside you can do what you want. Any changes, any moving of the bathroom equipment where you make changes to the sewage, all of that needs building plans. It needs the approval from the body corporate. And it's important to always check the existing building plans with what is actually on site. Now, a specific type of change that is very problematic, and if you get involved in a property where the garages have been converted in living spaces, you must give it a proper thought if you want to be involved in that transaction. As we have seen in the town planning scheme, there is a minimum parking requirement for a complex. Now, those garages form part of that minimum parking requirement. And therefore, if a garage is enclosed, technically, there's not enough parking left in the complex. And the idea that you can just park in front of your garage or around the corner is not how it works, because that everything outside of your unit belongs to all your co-owners, and you can't claim the garage for yourself for other purposes and then expect to park your vehicle on common property where you affect the ownership of that portion by all the other owners. As we said in sectional title, you buy the inside of your unit and an undividable share in the common property. So the area in front of your garage is not yours. It is owned by everybody that owns a unit in the complex. So in cases like that, we need to ensure that the plans was approved, that the owner have made other arrangements to have legal parking. Especially where you create it in a bedroom or things like that, it can change the parking requirements for the unit. But you still, even if you can solve all these problems, you still need building plans. Any room or structure may only be used for what it was approved for on a building plan. Now, it's not always a garage, for instance, the ceiling height might be lower than the rest of the house, and it may not be possible, even if you can jump through all the other hoops, to get that structure approved for residential purposes. So again, a big warning: if you need to deal with a property where the garage have been converted, you need to ensure that it was done legally, following all the processes. If not, it will be a misrepresentation to a buyer, and it can come back to bite you and can cost you dearly. It can even cost you the deal eventually, and there may even be other costs that needs to be paid. Now, as we said before, some people call it a SPLUMA certificate, but it's not really the correct wording. In Tshwane, whenever there is an addition or alteration where the PQ needs to be enlarged, we first need to apply to Tshwane to do that. We will need to submit the approved building plan, the approved sectional title plan with a zoning certificate, the site development plan if applicable, and they will only approve it if everything is up to date. Now, that will add another few thousand rand to the cost, and more importantly, in your case, it can add another month to 6 weeks to the whole process, and that can only be done at the end, after the building plans have been approved, after the surveyor general have approved the sectional title plans. So yeah, so add another month or 6 weeks to the process that we said can already take 9 months to a year. and see if your buyer will still be happy purchasing the property. The documentations that one should get from the seller or the body corporate then is the amended sectional title plans if it was approved. The conveyancer will then, you'll get the documentation from the surveyor general that was approved, and the amended sectional title plans will then be handed to the managing agent and the body corporate for the PQs to be amended. Now, just a bit of what we see in practice. What our company do in complexes is what we call a complex audit, and we basically obtain the existing building plans from council if it's available, and often it's not. We get the latest sectional title plans, and then we physically go and survey the existing sections, and we compare them, and we give a report to the body corporate, and it is quite scary what we find. This is just a typical example of a section. Everything in red was added, is not legal, need to be rectified in one of the ways that we discussed. Another one, you see there's huge changes made in lots of these units, and just an indication of one complex where 60 of the 80 units does not comply to building regulations, sectional title plans, and in this specific case, many of the structures will have to be removed because they can never be approved because they built over drains and servitudes and stuff. So, of course, the newer a complex is, the less additions and contraventions you will have, the better the trustees and the managing agent is, the less of that will be allowed. But in the older complexes, you will find a huge amount of sections that is not compliance. And therefore, if you deal with a specific complex on a regular basis, we recommend that you go to the trustees and ask them about the compliance of the complex, because if they start the process to get the complex compliant, it just makes your life much easier when you have a section to sell. Another example of how many additions is done in complexes that's not done legally, where building plans have not been submitted, where the sectional title plans have not been updated. So yeah, it's unfortunately a important part. So again, just for everybody that's involved in sectional title, the typical answer that owners have is that I got permission from the trustees. Note that that permission have very little, if any, relevance if all the other laws and regulations that we discussed have not been adhered to. And therefore, the fact that the owner tells you I have permission from the trustees should not lull you into believing that everything is fine. You need to have proof of all the other documentation as discussed. And if you have problems, you're welcome to contact us, and we can assist you with advice or assisting an owner to rectify what was done incorrectly. And often it can be that it was done by 3 owners back, but because nobody bothered to check the legality, the owner now is the one that will have the problem. Okay, that was just a quick, I can keep you busy for the whole day, but I think we have given you enough to be aware that there's much more to know and that you should be very aware when you deal with the sectional title section. So if there's any questions, we can try to answer it. Or if you need more information, you're welcome to send us an email and we can try to answer your questions. If there's specific areas that you would like us to cover, we can always speak to Werner and we can arrange a training session on specific issues, for instance, the building plans or the sectional title plans, or any of those. This is just a quick overview to make you aware of the complications when you deal with sectional title units. Any questions? I don't know if there's any in the chat. Otherwise, you're welcome to unmute yourself as well and ask your question, and we'll try to answer it for you.
We received one that someone's asking, does enclosing a balcony with burglar bars require building plans?
The question is, if it is enclosed by burglar bars, do you need plans? Now, as with everything, there is a lot of gray area. Personally, I think if it is just burglar bars and it is part of your section, it should not be a problem. But the moment you start to enclose it, where you build walls or you put aluminium frames and glasses in, I think it becomes problematic, and then you definitely need building plans. You obviously will change what your section look like, and therefore you need to make sure from the body corporate that they will be happy with it. But if it's only burglar bars, I think you can get away without submitting building plans for it, as long as it can obviously open and it's not a solid structure.
Okay, the next one, Frida Weingart, you've got your hand up. Can we unmute you?
Thank you.
There we go. Okay.
Hi, Aubrey. How are you?
I'm well, thank you. I hope you have learned something and I haven't confused you more than I assisted.
No, it's been very, very valuable. Just a clarification, when Werner spoke, he said when the PQ of the unit is increased, you have to get permission from the mortgaged owners. Is it not? Is it all the owners or only the mortgage owners, and why?
Okay.
Does it relate only to the banks?
No.
Please, thank you.
Okay. Remember we said whenever you increase your PQ, you are taking up some common property. So you are going to, let's say you add a room. That room is built at a place where before all your co-owners could come and sit in the sun and enjoy the common property. So any time when you're going to use common property, you first need the owner's permission. So you'll have a special general meeting and you need to have your addition approved, saying that I'm now going to make everybody's area that they have to enjoy less, even if it's by 3 or 5 or 10 square meters. So yeah, firstly, you need to get the permission of the owners. And secondly, what Werner referred to, if the increase in your section is more than 10%, then the bank, then you need the permission of all the bondholders, purely for the sake that, remember, when you get a bond from a bank, they give a bond on the inside of your section, plus the undividable share that you have in the common property. So that is becoming less, so the bank's value can be affected, and therefore you need the bank's permission. But you at any stage, even if it's less than 10%, you always need the permission from your co-owners, because you are going to use their common property for your private purposes. Does that
Thank
answer
you
your
so much.
question?
Yes, it does answer. It makes it very clear. Thanks, Aubrey.
Okay.
Okay, the next one. What is the position when there are no plans for the complex to be found at town council?
Okay, that's a very valid question. What happens if you can't find building plans? The responsibility to have copies of building plans lie with each owner and with the body corporate as far as the site development plan is concerned. Council have no responsibilities of keeping plans. As I always say, they keep plans for one reason only, and that's to lose them. But you cannot blame them. It was never their duty. It is the owner's duty. And that's why it is so important from a property practitioner's point of view that you ensure that a building plan move from the seller to the buyer. The moment the buyer becomes the owner, he is responsible for the building plan, and it's unfair, as far as I'm concerned, to move the responsibility from a seller to a buyer. So we often find that no plans can be allocated, and then plans for the complex needs to be redrawn from scratch. We undertake quite a bit of those exercises. It is costly, it can be costly, but it is a legal requirement. It's also cheaper to have all of the units done simultaneously than when it is for each owner to have to comply on its own. So, but the bottom line is it needs to be redrawn from scratch, submitted to council from scratch, and it gets approved, and then you must get certificates of occupancy for all the units.
Okay, the next one. What about swimming pools and solar panels?
Okay. Swimming pools, of course, always need a approved building plan. It's also very important to ensure or to understand who this pool belongs to. If a pool is built into a garden area and that garden is common property, of course, you have built a pool for everybody in the complex. You cannot keep them away from their common property. That's the nice thing. The sad thing is, should a child drown in a pool that's on common property, obviously everybody is responsible because it happened on common property that belongs to everybody. And therefore, it is important to ensure that if there's a complex, that all the pools are legal and that they are in exclusive use areas, or if it's common property, that it is safe even for other children, not only the owner's own children. What was the other one? Solar panels needs approval from the body corporate, and because you're going to put the solar panel on common property again. Remember, the roof is common property. So firstly, the body corporate needs to decide, do they want to allow that? Secondly, there must be conditions attached to it, because you are now going to attach those onto the roof. Some roofs are not capable of bearing the weight. There might be leaks in the roof because people walked on it or they attach the solar panels. And then secondly, it needs to go onto a building plan as well. But important is that you're going to change the aesthetics of the complex. Personally, the ideal situation is if the roofs are declared or created exclusive use areas with rules that determine who's going to maintain it, who's responsible when there's a leak in the roof, and all of those things, and try to keep it as consistent with each other as possible. You don't want 10 different companies, each putting up something that looks different, each one do damage in a different way, because eventually it can come back as a cost for the other owners in the complex if it's not done properly.
Okay, we bought directly from the developer and received no plans. What should we do?
Okay, yeah, sad. How long ago was it? If possible, it's best to go back to the developer. He might have copies of it, although often we find that they have not built exactly what was on the plans, and therefore they don't want to give it to you, or they just ignore it. You can go to council. If it's a new development, council should have copies of it, and it should be up to date. And you should also get a copy of the, what do you call it now? The occupation, sorry, the certificate of occupation, to state that the building inspector have inspected your unit and found that it was built exactly the way it was on the building plan. But the problem again is, once you become the owner, you become responsible for plans and stuff like that. But it shouldn't be a big problem in your case.
Can the trustees of a complex decide about solar panels, or is it the HOA?
Well, I assume that you talk about a complex that is a sectional title within a homeowners association. Now, one will first have to go and see if there's any rules in the homeowners association that might determine how, what, where, and if possible. And then, of course, it is the owners, the body corporate, not even the trustees, because again, they're going to use common property that belongs to everybody to erect those. So the ideal is to put rules in place in your conduct rules, so that everybody knows what is allowed and what not. Otherwise, it becomes problematic if each owner wants to do his own thing with his own company, and damage is done to common property. So yeah, it depends. If I understand correctly, one will first go to the homeowners association and see if there's any rules there, and then additional to that, there will be conditions for the sectional title scheme itself. Okay, that's what we have from our side. Are there anybody else that still want to unmute and just ask a question?
Aubrey, it's Freda again.
Okay.
I did a listing yesterday. When I looked at the boundary of the complex, I noticed that the boundary of the complex is encroaching on the vacant land next to it.
Okay.
I raised it with the body corporate, and they basically told me, mind your own business. What do I do? I've got an issue. I can't activate this listing because I also don't want to raise a hornet's nest, but I also don't want to sell something where I'm going to be held responsible in future, where I was I knew about it, and they're going to say, what did you do about it?
Yes. This vacant land, do you know who it belongs to? Is it municipal land? Is it a property that have an owner, or what would the situation be?
From our search this morning, it appears that it belongs to the municipality. Okay,
yes. Well, I think the right thing for you would just be to disclose it in the OTP. Just say that you are aware that this portion that is at this stage fenced in form part of municipal land, and it may not affect the quality of life of the buyer, but then he can never come back and say you didn't tell him. So let him sign for it. And except if it's directly, his area that he will use for his living area or living space, it typically would not affect the buyer so much. But you cover yourself by letting him sign. You can even put a little map in and or a plan in indicating which area is municipal land, and then you can just send it to the trustees just for them to take note.
Okay, thank you so much.
Okay. Any other questions?
Aubrey,
Yes.
thank you so much. It's Christian here.
Yes.
A very, very quick question, which is a bit of a curved ball, and I apologize for it in advance. I'm also a radio ham.
Yes.
And it often comes up at the club that the body corporates turn down any applications or any chance of putting up, and I must admit they're quite substantial, aerials, possibly with a footprint of around about 2 square meters.
Yes.
But obviously extend way above the units per se. Any advice there? Any thought? Any guideline there?
Yeah, well, you might not like the answer, but typically, a sectional title complex, I always refer to it, have some similarities with buying a franchise. You buy it with certain rules and certain understandings of what it is that you buy into. If you buy a KFC franchise, it comes with the rules, and you can't decide, listen, I don't like red anymore, so we're just going to paint everything yellow. That will not be allowed. Now, the same is applicable in a complex. And personally, I don't believe that somebody, if you need that type of structure for your hobby or for whatever it is, that complex is the place where you should buy. The rules was there before anybody bought into it. So you can imagine if each and every hobby must be, everybody, if you need something for your hobby or whatever, it needs to be allowed. It will create chaos. So personally, I don't believe antenna like that would belong in a complex, and therefore I think rightly so that the body corporate should not support it, because you anyhow going to build it on common property, so you will again need the approval of your co-owners that I don't believe that they will give. And therefore, I think in this case, I must give you the bad news that I don't think they should consider those type of things in a complex.
Aubrey, thank you very much. I fully expected your answer to be that. But having said that, you have left a little loophole there in what you've said, that in the event of approval being given by all the owners, there's a possibility. It doesn't affect me. I don't live in a sectional title complex 4. That's just one of the reasons, as I'm sure you're aware.
Yes,
But-
yes.
But
Okay.
reality is, yeah,
Yeah, you know, there's so many things that need to be considered, including things like insurance, safety, and I think certain things should just be left alone because it just open a can of worms. And if you allow that, what else can people come up with and say, but you have allowed this 10, 15, 20 meter Mars. Now, I just want to do this little bit or that, or build a little golf course here. You know, I don't think it's a good idea to start off those type of activities in complexes. Okay, any more
appreciate it.
questions? I think we'll give time for one more.
What type of interior changes needs approval besides structural changes?
Okay. Interior changes, if you don't do structural changes and you don't make changes to the sewage system, of course, whenever you add anything that will increase your PQ, we often find that where there's mezzanine floors, people enclose that double volume. And of course, that needs a building plan and that needs to increase the PQ because you have now increased the inhabitable area for which you should pay a levy by increasing the size of the floor of the mezzanine. If it is purely for painting or for anything that doesn't make a change to the structure, tiles on the floor or laminated flooring or things like that, technically you will not bother to submit building plans because it's not going to make any difference to anybody. But the moment you touch the walls, or the structure is changed, of course, that can be dangerous, and you need approved building plans, and you will need the engineer's certificate to go with those approved building plans. Okay, I think that was enough for one day. I hope you've learned something. You have our email address. Thank you, Werner, for the opportunity. And we trust that it makes your life easier as well, not having to deal with OTPs that where the sale is delayed by months or a year because of additions and alterations. Thank you for listening, and I hope you've learned something, and please feel free to contact us if we can assist with any of the things we discussed. Thank you very much.